Hear ye, hear ye. The United States Court of Appeals for the 10th Circuit is now in session. All those having business before this honorable court may now draw near, and they will be heard. God save the United States and this honorable court.
Thank you, and welcome to this Zoom session of the court. This panel will be hearing three cases this morning. We're starting with Waked v. Kerr, number 242064. Counsel, if you can hear us and we can hear you, then I think we're ready to go. So you may proceed, Mr. Pratt.
Thank you. May it please the court. This is an appeal from a district court's refusal to confirm an arbitration award. In our briefs, we've given you a number of reasons that that decision should be reversed, but you can decide this entire case by looking at two documents: the Federal Arbitration Act and the submission agreement that Kate Kerr signed when she first showed up in this arbitration with the first filings that she made in the underlying arbitration proceeding.
Did she make that under protest? Did she make it clear that she protested that?
She did not make clear she never protested arbitrating any claim asserted by Teresa Stone and Sean Waked, the only two people who actually got an award in this case.
Okay.
The submission agreement is at page A137. All it says is excluded from this agreement is commitment to arbitrate the claim of claimant Maestro Global. No consent of respondents to arbitrate with Maestro Global is made or provided herein. Otherwise, she said she agrees to submit the present matter in controversy, as put in the statement of claim, to the arbitration panel under the FINRA rules. She said she agreed to abide by and perform the award.
Well, was the claim being made on behalf of Maestro? I mean, I'm a little bit confused whether it was an individual claim or whether in fact, even though Maestro did not agree that was the claim that was being arbitrated here.
It was not. Teresa Stone and Sean Waked asserted individual claims against Kate Kerr.
Okay.
Now, one of those claims was as a third-party beneficiary of the Maestro contract, but even that claim did not belong to Maestro. It could not be a third-party beneficiary of its own contract. The claim that Teresa Stone and Sean Waked asserted was their own claim, and that is what she never at once objected to arbitrating. She couldn't because the FINRA rules required her to arbitrate that. Moreover, the Maestro Global...
Counsel, before we leave the submission agreement, could you explain the role of a submission agreement in this arbitration? In other words, why is the submission agreement a separate agreement to arbitrate and not just part of the arbitration process?
To forestall this exact situation here, so that you don't have somebody coming up after the arbitration's over and saying, oh, wait a minute, I didn't actually agree in that original submission agreement to arbitrate these claims. By having a post-submission, post-controversy, post-dispute arbitration agreement, you're plainly saying, okay, whatever was the scope of our original arbitration agreement, or maybe we didn't even have an original arbitration agreement, we are agreeing now that we are going to submit this agreement to arbitration. And the Federal Arbitration Act, in its plain language, says an agreement in writing to submit to arbitration an existing controversy shall be valid, irrevocable, and enforceable. That's separately from a pre-dispute arbitration agreement. And that's what we have here. That's exactly what this is. It's an agreement in writing to submit to arbitration an existing controversy. It is independently enforceable. And in fact, the district court did not cite a single case in the history of jurisprudence of this country for support of its conclusion that, no, you have to determine the scope of that in light of the original agreement. If there's a post-dispute agreement to arbitrate, it has to be enforced. And there was nothing in this agreement that suggested to anybody that Kerr was not really agreeing to arbitrate the claims that brought by by Waked and Stone individually, because if she was, that would mean that her entire submission agreement was completely meaningless. She wasn't agreeing to arbitrate anything, because the only things in the claim were claims of Stone, Waked, and Maestro.
Well, Ms. Kerr seems to be arguing on appeal that all of the Waked and Stone claims derive from the employment contract with Maestro. Do you agree with that?
I do not agree with that. They plainly do not. They had a separate employment agreement where she directly acknowledged in writing, and this is the document at page A318, where Ms. Kerr acknowledged in writing that she was being retained by Sean Waked personally, an associate of Raymond James. And the fact is, the slander claims.
Well, now that was an agreement with Waked, right?
That was between Sean Waked and Kathleen Kerr, yes.
But not with Stone.
Right. Okay, but even Stone's claims, she asserted them individually. They did not have to derive from the Maestro Global contract.
Does that include the third-party beneficiary claims, though? Wouldn't they be bound by the terms of the Maestro employment contract on that relative to the arbitration provision?
If they were suing the third-party beneficiary claims and they wanted to compel arbitration against Stone and Waked based on that, I think that would be correct. But that is not an objection that was ever made in this arbitration. There was no set-aside saying, oh, well, if any of their claims happen to be through the Maestro agreement, then we're also objecting to that. It was very clear they were agreeing to arbitrate the claims asserted by Stone and Waked. Moreover, it doesn't matter whether one of the claims would have been through the Maestro. All there has to be is any claim that the arbitrators conceivably could have found in favor of Stone and Waked. This court has to confirm, because it was all submitted to arbitration, and the arbitrators decided that they had individual claims that fell within the scope of the submission agreement that they agreed to arbitrate, which I would add, that's another point. The submission agreement also agreed to submit the question of arbitrability to the arbitrator. It necessarily did. It said they said they're submitting everything that was raised in the statement of claim and the counterclaim and answers, and jurisdiction was raised in all of those things.
But I mean, you're saying they agreed to submit whether it was going to be submitted to the arbitrator, but now you've referred to some general language simply saying all claims. Is there anything in the agreement that specifically says we agree to submit the jurisdiction of the arbitrator to the arbitrator?
No.
This says that in hike language. No.
In that language, no. The board It does not use that language there. What it says is she agreed to submit the entire controversy as set forth in the pleadings.
All right. And so entire controversy, in your opinion, I'm not saying it's not accurate, but includes whether it's submittable or not.
Yes.
Okay, thank you.
And weren't there two submission agreements? I mean, wasn't there something called an unqualified submission agreement? What's the difference between those two, and what role did those play?
The unqualified submission agreement is page A95 of the appendix, and it is the agreement that Kathleen Kerr signed with no exceptions whatsoever, agreeing to submit the entire controversy to this arbitration. The district court correctly found that that was not entered under duress. She didn't have to sign it. She did. Everybody relied on it for 10 months, spending hundreds of thousands of dollars. And it should be enforced. The Federal Arbitration Act requires it to be enforced.
Clear to me again what exactly she did object to, because I know she had a proceeding under protest to the arbitration for something. So I'm confused how her objection fits into your statements of unqualified acceptance of arbitration and jurisdiction to arbitrate.
The unqualified agreement was later on. Her original agreement, she objected to arbitrating with Maestro Global. That was in March of 2021. In June of 2021, after the arbitrator said, no, we don't agree with that, you need to submit an unqualified submission agreement, she did. And she didn't submit it with anything alongside saying, well, I'm still protesting this. I still don't agree with it. I'm keeping my fingers crossed behind my back as I submit this June submission agreement. None of that. She just signed it and submitted it, proceeded with the arbitration. We did not hear another objection to arbitration until 20 days before the hearing started, months later.
So the statement that there is no agreement to submit to arbitration is the Maestro agreement? Is suits against Maestro?
That was limited to the claims by Maestro. She objected to objected to arbitrating with Maestro Global.
Well, she never really backed off from that, did she?
Yes, she did when she signed the June agreement and submitted it without any qualifications or.
Well, okay, but when she filed her, but when Wakeett and Stone filed, or excuse me, when she filed the counterclaims, didn't she leave Maestro off of that?
She did.
Yeah, but isn't that an indication that she still doesn't think that the Maestro claim should be part of the arbitration?
No, her counterclaims were against Sean Wakeett personally. She wasn't
No,
asserting.
I understand that, but she said in the counterclaim that the reason she wasn't naming Maestro is she didn't agree that there was jurisdiction over Maestro, and that was long after the unqualified submission agreement. So it seems to me she said the claims by Maestro shouldn't be here. Does that really matter? Does that really matter though to your argument?
It doesn't really. I mean, waiver is one grounds you could address this on. But the fact is she signed an unqualified agreement to arbitrate the claims asserted by Wakeett and Stone.
Your position is that she did make objections verbally, but in the final analysis, she agreed to submit unqualifiedly the claims that are now on appeal. And so whatever her earlier hesitations is overridden by her written submission. Is that your position?
It's not that she said it verbally. No, that she never objected to arbitrating any claim asserted by Wakeett and Stone individually.
Counsel, can I jump in here and get back to the counterclaims? I'm wondering, I guess your argument is through the counterclaims, she waived any objection, right? And I guess I'm wondering, doesn't that dispose of the case? You seem to want to go to your first argument, which you've been going on with, but I guess I'm wondering, doesn't the counterclaims, in your view, doesn't the counterclaims argument take care of it?
I think so. I think under the Hicks case, you can't pursue a counterclaim, pursue sanctions, get the sanctions award, take the money, and then later on claim, King's X, heads I win, tails you lose. We didn't agree to arbitrate this claim. That's certainly what Judge Ide is talking about. Certainly has been my understanding that if you ask for affirmative relief in an arbitration, you bought the whole turkey. That was my argument as well.
Well, I guess I don't understand then why you haven't been pressing that during argument.
Because y'all have been asking me about the other. I had it down later on there, but no, I think if you want to go to the waiver argument, I think waiver is clearly established. In other words, if you participate in an arbitration, you're bound to it unless you are waived any objection, unless you maintain your objection consistently and vigorously. And there could not be anything less consistent than signing 2 submission agreements, filing a counterclaim, filing a motion for sanctions, getting an award, taking the money. That is about as inconsistent as objecting to arbitrating with Sean Wakeett and Teresa Stone as you can possibly imagine.
Thank you.
And I take it you made all these arguments in district court?
Yes. To the extent they were raised, and there was some of these arguments. I mean, the judge came up with some of these for the first time in his opinion. I mean, this whole thing about you had to introduce, that the submission agreement was part and parcel of the original agreement. That was all. I don't think that was ever raised before, but I don't think this waiver and agreement argument has been before the district court from the beginning. Although I will say, it was not in their original objection. Their original motion to vacate just argued manifest disregard of the law. It was only not until their reply brief that they first said, oh, wait a minute. No, actually, we're going to say we never agreed to arbitrate it. Because they didn't even believe that. I was going to reserve some time, but it looks like if you don't have any further questions, that I'm just about out of time. But if you don't, I would ask you to follow the Federal Arbitration Act and confirm the arbitration award that Sean Wakeett and Teresa Stone put a lot of effort into obtaining.
Thank you, counsel. Counsel, you may proceed.
Thank you, Your Honor. May it please the court, Christopher Salcedo for Kate Kerr. I'm going to address some of the questions that this court has asked this morning. And I'll start with this. What Judge Browning found was that Mr. Wakeett and Mrs. Stone's claims of liability against Kate Kerr arise from her employment relationship with Maestro Global. And it is not disputed that Mr. Wakeett and Mrs. Stone assert that they are third-party beneficiaries of that employment contract. In fact, they pursued damages against Kate Kerr pursuant to that contract. What we did not hear from Judge Browning opinion or today is a claim that was brought by Wakeett, Mr. Wakeett and or Mrs. Stone independently that did not relate to Kate Kerr's employment with Maestro Global. And that is important for this reason. The arbitration provision within the employment agreement with Maestro Global states that all actions that arise from or relate to the employment agreement. Well, of course, that is now very broad. It is not simply just a contract issue. It is anything relating to the employment of Kate Kerr and Maestro Global. So that's what the court found. And
counsel, in the arbitration proceedings, did Ms. Kerr object to arbitrating all of Wakeett and Stone's claims?
To be specific, Your Honor, she objected to the claims of Maestro Global because to her, Maestro Global is the only party to which she had a relationship, and that was an employment relationship and a contractual relationship.
Well, but counsel, Wakeett and Stone brought tort claims. They brought contract claims. Ms. Kerr only talks about Maestro. Why didn't she single out the claims by Wakeett and Stone and object to those?
Because all claims relate to her employment with Maestro Global.
I understand your argument, but didn't all she had to say is, I object to the claims by Wakeett and Stone. Did she ever say that?
My understanding, Your Honor, is that she was clear that it was Maestro Global and the claims.
Well, if that was so clear, let's get back to the counterclaim. Mm-hmm. How could she objected when she asserted counterclaims against Wakeett and Stone?
That because it was part of the process. She objected to participating in the FINRA arbitration process. And once she was compelled with the threat of sanctions to not only sign the submission agreement, but also to go through with the arbitration, that was part of the process. Said another way, it could easily be argued that she would have waived any arguments that she may have had if she had not pursued. So it was part of the process, and she filed under objection. And Your Honor asked a question earlier about the objections, and Judge Browning found that they were made consistently and vigorously, beginning not only with the answer to the statement of the claim, but throughout the process, all the way to closing arguments. So at
Yeah,
the beginning of the hearing, the end of the
But
hearing,
weren't the objections to arbitrating the Maestro claims? Wasn't that what Judge Browning was talking about? Isn't that what Ms. Kerr was talking about during the arbitration?
yes, because all claims relate to the Maestro employment. Kay Kerr was not, of course, a party to the underlying sale of a financial institution. Her duty, if you will, her relationship with Mr. Wakeett and Mrs. Stone is solely based on that employment agreement, on her employment with Maestro Global. That's it. That's her relationship with them. That is her involvement in this case. So by objecting to Maestro Global and the claims brought by Maestro Global, so not just the party, but the claims, we submit encompassed the third-party beneficiaries who Mr. Wakeett and Mrs. Stone clearly argue that they are.
Okay, so let me just make sure I understand what you just said. So when Ms. Kerr objected to the arbitration of the Maestro claims, I think what I'm hearing you say is that she was also objecting to the Wakeett and Stone claims because they related to the Maestro employment contract. Is that your argument?
Correct. And okay, because they are admitted.
My question to you is, why didn't she say that to the FINRA panel? So I said, I object to the Maestro claims. Okay. Why the next part of it, if we accept your argument, is why didn't she say, oh, and we also object to the Wakeett and Stone claims because they all relate to the contract? Was that ever stated to the arbitrator?
I believe her understanding when she was making these objections was that she was making that. If Your Honor, which Your Honor is asking for a specific document or language, and I cannot point the court to that specific language, but that was clearly her intent in arguing that all claims relate to her employment with Maestro Global, because it's again, it's her only relationship to this matter is through Maestro Global. With that, the other question that was raised has to do with the submission agreement, and it was discussed as Ms. Kerr filing an unqualified submission agreement. Well, that of course came after she again was threatened with sanctions from the panel, and she was instructed to sign or essentially face default. So what Judge Browning found that in this situation, by signing the submission agreement, it again was part of the FINRA process that she had already objected to. And that is supported by the FINRA rules themselves. If you look at FINRA Rule 13303A, it states that upon a party being served with a statement of claims, that they are to then not only answer, but also sign and date a submission agreement, which to the court's question earlier is quite an odd request if it's a separate contract. Said another way, if Rule 13200 already establishes the requirement for arbitrability, of the arbitration, what's the point of a submission agreement? Judge Browning found in this situation that it was simply part of the process. It was a requirement, somewhat of a entry of appearance as for the parties. It was nothing more than that. So alone, it certainly does not show an intent of Kate Kerr to submit to the FINRA arbitration. Similarly, the counterclaims that were brought and the question from Your Honor, same thing. It's a process. It is part of the arbitration process, and Kate Kerr objected to the entire process.
I'm intrigued about that. The impression I got was you were saying that her agreement was under duress, and therefore we shouldn't give it full impact. And yet I've always been taught that merely because you feel duress because you don't like the situation you're in, you don't like the contracts or agreements you're in, and you are being forced to make decisions that you don't like economically because you don't feel like you have a choice, that doesn't qualify as duress. We have to evaluate, people all the time get boxed in by things they have agreed to, and that simply is not duress. So I don't know how much weight we should give to all this stuff about she's under such stress and duress and doesn't agree. How can you not agree and then go forward and ask for affirmative claims?
And I appreciate that question, Your Honor, because I think that is answered by the Supreme Court in first options and by Your Honor in your decision in Lewis, of course, versus Circuit City. Because what was understood is that as long as Kate Kerr was making continuous and vigorous objections to the federal process, that her objections were preserved. In other words, as in this situation, even though the FINRA panel continued with the arbitration process, she made her objections consistently, vigorously, therefore maintaining her ability to challenge the jurisdiction of the court. Of course, it would have been certainly more elegant if the FINRA panel at that time would have simply stayed and allowed that issue to be resolved. But she did not have that option. Her option was essentially either participate under objection or allow the arbitration process to continue without her involvement, as is a possible sanction from FINRA for failing to sign a submission agreement. She could have been prevented from providing any evidence, providing defenses such as affirmative defenses, and left out of the process. At that point, she would be risking essentially a default judgment, which I think is certainly agreed upon, usually results in an excessive judgment. So the option was participate under objection and protest, or do not participate and hope that the argument later is successful after an excessive judgment has been entered by the arbitration panel. And I think that's really what she was looking at. We do not argue duress, to be clear. I do not think that is the argument. Again, it's a part of the process, and Kate Kerr objected to that process. And
if you don't label it duress, what legal title do you hook to it? Her statement that I don't like what I'm being required to do, but I'm doing it anyhow. And now I want to later disavow it. If that doesn't fall under duress, which you're disavowing, give me the legal title that you think it does fall within.
Well, we rely on part of the Federal Arbitration Act, Section 10A4, which is they exceeded their power. And they exceeded the power in governing an arbitration over objection to not only a party, but the claims brought by that party. So that is what we argue. Duress, admittedly, again, is a little different. And to Your Honor's point, though, what Your Honor described was much more a situation such as Lewis, which is Lewis tried to take two bites at the apple. That is not what Kate Kerr did. Kate Kerr, from the beginning, objected, saying, Maestro, I did not agree to arbitration in FINRA with Maestro, and therefore all claims related to my employment with Maestro, I object to. That's what she said. She did not wait to see what the outcome was before making her objections, unlike in Lewis, which is clearly what the claimant did in that situation. This was quite different.
Well, counsel, could I just, on the submission agreements, we've got the initial submission agreement, then we have the unqualified submission agreement. I want to go back to the first one. I'm looking at it right now, and it lists as claimants Maestro, Stone, and Waked. And then in the first paragraph, it says the undersigned, meaning the respondents, and Ms. Kerr, submit the present matter in controversy. And then they say, however, excluded from this agreement is commitment to arbitrate the claimant Maestro Global. And that's it. And there's 3 claimants. So it says, we want to accept out, we don't agree to arbitrate with Maestro. And then the very same page, you've got Stone and Waked as claimants as well. So I just don't, I guess I'm having a hard time understanding how that exception or the exclusion extends to Waked and Stone when they aren't even mentioned. And they don't say all the claims against them derive from the claims against Maestro.
The statement of the claims talks about the acts and omissions that set forth herein constitute breaches of the applicable agreements and Kerr's duty owed to Waken and Stone as intended third-party beneficiaries.
Where are you right now?
That is appendix page 84, volume 1.
Well, I'm looking at appendix 137. It's the submission agreement.
Mm-hmm.
And that's what I asked you about.
Well, and I appreciate it. And again, because Waken and Stone's claims flow through their status, their position as third-party beneficiaries of the employment agreement with Maestro, by objecting to not just the party Maestro Global, but also to the claims brought by Maestro Global. She is in essence objecting to any issues that arise of or relate to that agreement.
I'm going to, this belabors the point, but it says the exclusion is to the claim of Maestro, not the claims. It's not claims plural. It's the claim of Maestro. That's all that they're excluding from their submission agreement.
The Maestro did not bring simply a breach of contract. They I believe admittedly brought multiple claims themselves. They simply did not get an award for those claims. So to say, I guess, claim as opposed to the plural claims, I do not believe encompasses what was intended by either the claimants, Maestro, Waken, and Stone, or the respondents, and that is, in this situation, Kerr. So I do recognize that I'm out of time, but I am happy to answer additional questions.
Further questions?
No.
All right. I think we've exhausted the allocated time, so we will thank you for your arguments.
Your Honor, could I have 30 seconds to address just one fact pleadings issue?
Well, we did let Mr. Ceseda go over, so I'll give you the 30 seconds. Go ahead.
Okay, just to correct, earlier, I believe you said that you thought the counterclaim was filed after the unqualified submission agreement, and I don't believe that's accurate. I'm looking back at my pleadings file, and she filed the counterclaim in March of 21, and all she said there was she denied that Maestro Global is a proper party to this action, but then she filed the completely unqualified submission agreement 2 months later and 3 months later in June.
Okay, thank you for that clarification. We'll check the record. Anything further? All right, we'll consider the case submitted. Appreciate your cooperation with a remote argument. I thought it went well. At least we didn't have technical difficulties, and counsel will be excused. Thank you.
Thank you, Your Honor.
Right, we'll proceed with our next case this morning. It is Willis versus Oklahoma County Detention Center, number 246247. And counsel, I think, Francine, your counsel for appellant, you may proceed.
Thank you, Your Honor. May it please the court, Derek Francine, on behalf of the estate of Mitchell Willis, who died while in custody at the Oklahoma County Detention Center, a detention center that has had long-standing issues and concerns and constitutional violations against its detainees for many years prior to this event. So much, in fact, that the Department of Justice had to intervene and enter into a memorandum of understanding to start overseeing and exercising control over them to get back on path of having a constitutional facility. In this case,
You said there was an overseer?
they come in, they do inspections, they evaluate issues, they identify concerns between staffing, funding, failure to provide medical.
And how long did that overseer remain involved?
They are still involved.
Okay.
In this case, plaintiff has had 3 separate attempts to bring back in the county to hold them accountable for their policies, procedures that were the moving force behind the death of Mitchell Willis. The first one was an amended complaint that a motion to dismiss was granted. Plaintiff had very limited facts, no discovery in order to fully flesh out all the details. And the court just found that there wasn't sufficient information to move forward finding a policy violation. Plaintiff believes that the facts ultimately bore out that the allegations claimed by plaintiff were presented to the court in subsequent filings as well. And I think this highlights why the motion to dismiss stage, if there's any evidence and allegations suggesting that there is a moving force behind the policies and procedures causing the injury of the person who has a constitutional violation, because it's not disputed that the other 2, actually, I think there was 5 individual defendants at one point, 2 of which the court allowed to move forward, finding constitutional violations and denied qualified immunity, that it was based upon the training, especially in the instance of Jonathan Johnson, which gets us to the motion to amend the complaint to try to join back in the county after limited discovery was done. The parties did not get a scheduling order until late in 2019. I believe it was November 2019 at some point. As we all know, COVID hit in March of 2020. At that time, the plaintiff had issued written discovery, issued requests for admissions, and even requested depositions that were not scheduled yet when everything was shut down. In order to preserve any concern over Oklahoma's savings statute in amending the petition to bring back in the county on a motion to, after a dismissal without prejudice, plaintiff filed his motion to amend based upon evidence and admissions of Jonathan Johnson and other information obtained during that time period. That included Jonathan Johnson himself admitting in a request for admission that his maneuver performed on Mr. Willis that caused the injury was based upon his training received at the Oklahoma County Detention Center. This was not a maneuver that he came up with on his own. This was not a maneuver that he performed based upon some outside training or just some rash decision. He was following his instructions and performed a maneuver which is called a 3-point maneuver, and it's where you place your foot, wedge it within the neck of the person that you're supposed to be using it when they're combative. The testimony ultimately bore out from the training officer, Officer Slayton, that he gave them full discretion to use it at any time that they wanted to. They were not prohibited under Oklahoma County Detention Center training rules to perform it on non-combative detainees. And so this maneuver was put in place. He puts his foot in there. He's trained that if he wants to hold the person down further, he shifts his weight from his toes to his knee, which is critical because Officer Slayton also instructs them to place the knee diagonally over the spine, which is the critical fact that is contradicted by the appropriate training techniques of this maneuver by Major Heron and Jason Ruge and plaintiff's own expert, in this that you should never cross over the spine because of the concern and risks that are known to
So,
cause injury
so
to the
you
spine.
you made this sound like part of the training process was put your knee across and over the back. I'm a little confused about that. I mean, uh, where in training manuals or processes or proceedings is it said this is the way we teach this 3-point maneuver?
Well, there's two places you could look. One is an affidavit of Jason Ruge that is in the record, and he ultimately contradicted his own affidavit from another case. I believe that's at Appendix Volume 2, page 566. He shows himself in this position and you can clearly see his knee is directly over the back. The second main point is Officer Slayton.
That affidavit was not a training. That was an after the fact statement, demonstration of how he thought it should be done. So, but your statement to the panel was that they were trained to do it the way it in fact was done. And my question is, where is the evidence of that they were affirmatively trained with evidence, not historical or after the fact, but
well, Officer Slayton, the training officer, confirmed in testimony that he trains officers to put the knee diagonally over the spine. Appendix Volume 3, page 56. And Jonathan Johnson affirmed that he was trained to put it at the 45-degree angle over the spine. Now, and it's Heron and Ruge that say, wait a minute, that's not how it should have been trained. They weren't the training officers. They were supervisors to Slayton and never corrected Slayton in training it in this fashion. And they said the appropriate way to train it is you put your knee parallel to the spine. One of them even described the spine as an equator, and you say on your side of the equator. And that is the critical moving force behind this. If Jonathan Johnson is never trained and isn't purely just following his training, thinking he's doing what his instructors and his training instructor told him to do, he is never going to put Mr. Willis at risk for this spine injury during this positional restraint when Mr. Willis, it is undisputed that Mr. Willis was non-combative during this time period. There was zero reason.
The point I just wanted to make was the evidence of their training that you're relying on is testimony and demonstrations after the accident. I'm asking, what I thought I was asking was, is there training material or demonstrations or videos before the accident that supports this is the way you're being trained? That is before this accident happened.
There are no videos or instruction manuals that they provide any of their training, any of their officers on how to perform this maneuver. So we must rely on Officer Slayton's testimony and how he affirmatively trained Mr. Johnson prior to this event. This training was done prior to this event. He testified. So I think all that would be just another fact, another piece of evidence that supports the statement. I think we can't discount the statement of a training officer.
I understand, and I understand that. Okay, that answers my question. Thank you.
Okay. And I think
Counsel, could I just jump in and ask for some procedural context here? It seems that the evidence you're pointing to and the arguments you're making now go to your second issue, which has to do with the denial of leave to file the amended complaint. Is that correct? Is that what we're talking about?
Correct. It's both information raised and presented at the denial to leave and information raised and presented at the motion to reconsider stages that the court abused their discretion.
All right. So you're not arguing that the original decision to dismiss the amended complaint, at least I haven't heard any arguments this morning that we should reverse on that decision.
I think we did make arguments on that, and I think there are bases in the amended complaint that show that statements were made that support the subsequently found information. There's the only one real tweak to the information found was that we thought it was a knee strike due to the severity of the injury caused to Mr. Willis. We assumed that this had to have been some sort of big strike
Well,
for
I guess I mean, this may be getting a little more technical in terms of procedure, but if we disagree with your argument on the second issue, the futility issue on the motion for leave to amend, if we disagree with you on that, doesn't your first issue fail as well?
I think the concern would be is we never had the opportunity to do full discovery on this county, which is why the motion
Well,
could allow
counsel, let me just put it this way. You're saying that the discovery process revealed information that was not available to you in drafting the, I guess, the amended complaint.
Correct.
And so you're coming back to the district court and saying, oh, look, we just we took discovery and now we're enhancing our complaint. We can make it better. We want you to let us file a second amended complaint. And my question to you is, doesn't this appeal hinge on that issue? Not the first one, because if we rule against you on the motion to amend leading to a second amended complaint, how can you succeed on your first issue?
And I will concede, if you believe that the information provided is futile, that would end the argument. But I would want to point to the recent decisions beyond what plaintiff presented, the Weigel v. Broad and Booker cases, the more recent ones, Kruger and Lynch, that were determined, or I guess Kruger and Teets, that were determined that showed this type of positional restraint, the prone positional restraint on a non-combative person is a constitutional violation. And on top of that constitutional violation that has been confirmed and said longstanding by this court is the moving force of the dangerous knee position over the spine that the district court determined was not futile as it pertained to Jonathan Johnson. And if a defendant officer is purely following his training, how can that not be the moving force behind the ultimate injury if that action is deemed to be unconstitutional? And I would like to reserve the remaining time for rebuttal.
Thank you, counsel. Mr. Hendrickson.
May it please the court. My name is Jeffrey Hendrickson, counsel for the appellee, the Board of County Commissioners for Oklahoma County. Your Honors, the district court properly dismissed plaintiff's amended complaint. And to be clear, there was an original complaint that was filed. And then prior to, I can't recall if it was served or not, but prior to any action by the defendant, there was an amended complaint that was filed. So the operative pleading for the first instance in the court's review in the 2019 order was actually an amended complaint. The district court's decision to dismiss the amended complaint as failing to state a Monell claim, a claim of municipal liability against Oklahoma County, was correct. Beyond that, the district court's decision to deny the plaintiff's motion to amend, which was filed after the deadline to do so, was also correct. And lastly, the district court's decision to deny the plaintiff's request for the district court to reconsider its order denying the motion to amend was also correct.
Counsel, do you agree with the district court that the first amended complaint plausibly alleged a municipal policy or custom?
Your Honor, we're not contesting the finding from the district court in that instance. However, the district court's finding in that regard was sort of narrowed down to the sheriff of the Oklahoma County Sheriff's Department was the policymaker for the jail. And that was the basis for the district court's conclusion that there was a municipal policy at issue. And so the briefing in this appeal hasn't really had anything to do with whether the municipal policy was established. But for the purposes of the argument today and for the briefs, we're not contesting the district court's finding that a policy was established. The district court, whether or not was right about that, was plainly correct as to its conclusion that the estate had failed to plead any allegations which would have suggested that the county had any notice of problems with training, had any reason to believe that there was an issue that would lead to potentially a constitutional violation. And so as such, at the very least, there was no causal relationship, there was no moving force, and there certainly was no deliberate indifference. So whether or not
Okay, counsel, if you can hear me, you're frozen on screen, so we'll see if we can get you back. Let's see, I think, Mr. Francine, you're still with us.
I am.
Okay, I think the rest of us, I think this is at Mr. Hendrickson's end. Mr. Jerome, can you jump in and tell us what we need to do?
Judge, if you want to give me a moment, let me try getting in touch with Mr. Hendrickson. Oh, he disconnected. Let's see if he reconnects.
All right.
In the meantime, I'll start grabbing his contact information. Oh, he's calling right now. Bear with me one moment. Judges, Mr. Hendrickson just called. His power went out in his office, but it just came back up. So he may just need 1 or 2 minutes to get his Wi-Fi reestablished.
Wow. Well, you can't blame him if the power went out. I was afraid he had violated rule number 1 of computers, which is if it's working, don't touch any buttons.
I don't see him attempting to join just yet, but it may take his Wi-Fi a moment to reconnect. Judge Matheson, while we wait for Mr. Hendrickson, where would you like me to leave the timer where it is?
Yeah, I think that's fine on the timer. If it's going to take, we think it's going to take more time, much more time for him to reconnect, I think we probably ought to discuss our options.
Well,
One,
I'm sorry, Judge, he's joining right now.
okay.
I'm very sorry about that.
Well, you can't control the power going out, right?
Some sort of power surge.
All right.
Imagine my surprise. So,
okay. I don't know if you remember where you were. You were sort of in mid-sentence, and
I do.
We'll be a little flexible on the timing on this to make sure you get a chance to present your argument. But you can pick up where you left off. Let's proceed.
Thank you, Judge Matheson, and I appreciate that. And again, my apologies to the court and to my colleague on the other side.
I don't see, excuse me, I don't, oh, there we go. Okay, I didn't see the timer going down, but it is now.
Very good. As I was discussing, I don't necessarily think the district court was correct that a municipal policy was found, but I don't think it is outcome determinative because I think whether or not the finding of deliberate indifference points to the existence of a policy, which I think that is actually what the law is, versus whether the finding of deliberate indifference points to the existence of a cause is, kind of immaterial. The argument where the district court was correct was that the original amended complaint did not contain any allegations which would have established deliberate indifference, which is a requirement under cases like Connick v. Thompson, which discuss what must be shown in the event the allegation is that the municipal policy was one of failing to train or failing to supervise. And I don't think there's any disagreement that the policy at issue would be the allegation of a failure to train. So, Your Honors, that's why it's kind of important to start off exactly with what this case is about. It has several procedural components to it. It has standards involved at the Rule 12b6 motion to dismiss stage. It has standards involved at the motion to amend stage under Rule 15, and then the interpretations of Rule 15, including that amendment should not be allowed if doing so would be futile, which itself incorporates the Rule 12b6 standard all over again. And then it involves standards at the motion to reconsider stage, where the district court has the ability to rule, and it only can be overruled if it's found that the ruling from the district court was arbitrary, whimsical, or capricious, or in some manner in that regard. So there are multiple procedural components to this case and different standards to be asserted. But the central key of this case, and what I didn't hear any words on this from my colleague on the other side, and I think I understand why, is because it has everything to do with municipal liability. In fact, I think I heard Mr. Francine tell this court that how could it not be the moving force if it's the case that Mr. Officer Jonathan Johnson had said, or it was found that his action cause was an unconstitutional violation, unconstitutional use of excessive force.
Well, Mr. Hendrickson, one of the procedural components that makes this case a little different from the usual 12b6 motion to dismiss is that there's discussion in the briefing about the discovery, what came out through discovery after dismissal of the first amended complaint. And there's sort of a summary judgment feel to that, because we're looking at the complaint, but there's also arguments based on what is in the discovery record. And so I guess the question I have is, if we're still talking about 12b6 and amendment and futility, should the district court and should this court be looking strictly at what was alleged in the amended complaint or the proposed second amended complaint? Should we even be looking at the discovery record? Why wouldn't that convert this into more of a summary judgment discussion?
Your Honor, I think this court can rule for the appellee of Oklahoma County, even if it takes a look at the proposed second amended complaint and just reads the allegations on its face. I think the court absolutely can do that. And I frankly believe that is what the district court did as well. In its order denying the motion to amend, was it assessed specifically the allegations that were made or the proposed allegations that were to be made by
okay, but in the proposed second amended complaint, here's one of the allegations. I wonder what you would say about this, or what we should say about it. There's an allegation that defendant Johnson admitted that any use of force on Mr. Willis was based on training received by the OCDC, including placement of his knee on Mitchell Willis's spine. Why doesn't that plausibly allege a policy causing injury?
Judge Matheson, that's an absolutely fair question. And the reason for that would be because of the holdings from the Supreme Court that discuss, and I believe Pembauer v. Cincinnati is one, Proprotnick v. the City of St. Louis is another, but that discuss how individual officers' statements about what their training was or what their training was not, by themselves do not serve as the basis for any sort of municipal policy. So Officer Johnson could say, well, this was based on my training, but that doesn't make it his training. And even if you assume that to be true, it still does not relieve the estate of the obligation to establish a municipal liability claim. And that leaves open the door for the additional requirement that they must show, which is, okay, that was based on the training. Did the county have any idea that a constitutional violation was going to occur because of the way that it was training its employees? Did the county have any idea that a constitutional violation was likely to occur based on the way it was training its employees? Did the county have any reason at all to believe that the way it was training its employees could result in a constitutional violation? And so even if you look at the proposed second amended complaint, and even if you say, we won't look at any of the actual discovery material that was submitted to be ruled upon, the outcome would be the same, because as Judge DeGiusi and as the district court found, even if you credit those as accurate, you still have to bridge this gap, and the estate did not do so. The only effort the estate made to do that was to cite two items. One was a 2008 Department of Justice report, which was issued 9 years prior to the alleged facts in this case, which happened in August of 2017.
But was there continued supervision of the sheriff's office after that?
Your Honor, at the time in 2017, when the allegations occurred, I certainly am not aware that there was continued supervision. But even if there was continued supervision at the time, Judge Ebel, the fact of the matter is there's nothing that's been put in the record in this case that would have to do with continued supervision for the types of facts that are at issue in this case. And that was frankly...
And we're really dealing with pleading. I mean, I think your point is that this is a pleading analysis rather than a factual analysis. Is that right, or did I just get that inversed for you?
I think that is certainly a way that this court could go. And that's back to Judge Matheson's question as to what do we do with this discovery material? I think that in moving to amend, the court is certainly allowed to consider any of the items that are put before it when it determines whether or not the allegations are sufficient, in the same way that the court would be permitted to consider any discovery material that was attached to the amended complaint to begin with, which in this case actually was the Department of Justice report. It was submitted as an exhibit. So my position would be Judge DeGiusi, the district court, was certainly allowed to consider the discovery material that the estate put to the court when it moved to amend its amended complaint. But even if the court considers only the facial allegations, it's just a question of
I'm interested in that point though. Why was the district judge permitted to consider this material that is outside the four corners of the complaint? Why is that permissible in a 12b6 type context?
Well, Judge Matheson, my recollection is that, and I believe the record shows that material was submitted as an effort to move to add. Basically, it was a request for an admission from Officer Jonathan Johnson, where he said, "Yes, I admit everything that happened was was based on my training, and then it was also some emails. And as far as I understand it, that was considered because it was submitted to the court. But even if the court erred in considering those materials, looking directly just at the text of the proposed second amended complaint itself and finding that it was futile was an appropriate decision for the court to make. And that goes back to my point with respect to bridging the gap between an unconstitutional event occurring and establishing municipal liability. And so I believe that the district court was correct in its assessment that, even if it considered the truth and adjudged those allegations to be true for the purpose of the motion to dismiss, what was not shown, and what Mr. Francine has spent no time on, is bridging the gap. And what is bridging that gap? It's the causal connection between the underlying event and the municipal state of mind. And in this case, there is nothing that has been submitted at any point that would show that causal connection, that deliberate indifference, that municipal state of mind. It wasn't pled in the original amended complaint. It wasn't contained within the proposed second amended complaint. And none of the materials that were submitted to the district court, for example, on the motion to reconsider, would have established that additional prong, the causal prong, the deliberate indifference, existed in this case.
Well, those are two prongs, aren't they? I mean, there's causation, but you also have to show deliberate indifference, right?
And that's correct, Your Honor.
What would the complaint need to allege to show deliberate indifference on their training theory?
Certainly. So you can establish on the training theory by allegations of similar conduct close in time, where an officer has taken an action that was similar or close to similar, that would have been in the same time period where the type of training involved would have been similar. And you could allege, hey, here's what happened in 2015 and 2016, for example. And you had these incidents, all of which stem from a use of force. And I would add, in fact, that exact scenario was presented by the Layton v. Board of County Commissioners case. That case is a 2013 appendix opinion from this court that discussed the denial of medical care to an inmate who was known to have medical conditions and need medication for those. And the allegations in that case were that the medication wasn't provided despite the knowledge from the officers that it was needed. And the way that municipal liability was established in that case was by referring to the 2008 Department of Justice report, which factually occurred only a year before the allegations in the Layton case, and elicited basically specific facts that the Department of Justice found that were not happening at the jail, many of which had to do with the passing of medication, the paying attention to inmates and knowing of their medical conditions. And so not only because of the DOJ report in 2008, but because of the Sheriff's Department's own investigations 2 years prior to Layton, an additional outside agency investigation just prior to Layton, the 10th Circuit in that case found that there was a pattern of conduct shortly beforehand that would have given rise or given the basis for a failure to train claim. Unlike this case, which the DOJ report happened 9 years before, Layton happened at least 5 years before, and had nothing to do with what the allegations in this case were. So, Your Honors, I see I'm running out of time. We would urge this court to affirm the rulings of the district court in this matter. And I'll take any questions if needed. Otherwise, thank you.
Thank you, counsel. We have some time for rebuttal.
Yes, thank you. I'd like to just start with the why does a report of, if they're continuing under DOJ supervision, which they were at this time, why is a report that also talked about the prevalence use of force by the staff as being a constitutional issue by DOJ not be relevant? Just because the report was written 9 years ago doesn't mean that they're not still having issues.
We are dealing, I'm confused because we're really dealing with pleadings here. That's what Judge Matheson pointed out. Was there anything in a pleading that they are under continued observation right now?
I don't know. I think it was inferred. The inference.
Well, not inferred. The question was whether it was correct to dismiss the case on a pleading in a pleading environment. Was it ever pled that they are under continuing examination now because of their the fear, I guess, of the current policy, which is reflected by past offense.
I'd have to look closely at the amended complaint to see whether that was pled, but it's my belief that it was. But regardless of whether that's the hinging point, the notice on a municipal's constitutional violation also hinges on them updating their training based upon rulings by this court and the Supreme Court. In 2014, in the Booker case, the courts declared that putting weight on a detainee's back who is non-combative is a constitutional violation, and that was agreed to by Ruge and Herron. Unfortunately, the county continued to allow Austin Slayton, one of their head trainers on uses of force, to continue to train Jonathan Johnson and others in this manner. It doesn't matter that Jonathan Johnson at this stage was the only person to cause the injury. The notice is knowing that you're training someone in an unconstitutional manner, which over the spine is unconstitutional, dangerous, and it occurred in this case and severed the spine of Mr. Willis.
Well, aren't you also making a claim? One claim is that process, that three-point process, was unconstitutional. But the second argument I thought was that their observation of the person in the cell was inadequate. Is that am I correct or incorrect that that's being alleged as a separate claim?
That's incorrect. What we were doing is using the officers, I believe it's Cornelius, his observations confirming that Johnson placed his knee and weight on Mr. Johnson's spine, confirming the facts that was the mechanism of injury at the same spot, not a failure to intervene. So
no, I'm not talking about failure to intervene. Are you or are you not claiming that the observation of the defendant, I mean the decedent, was inadequate? Their monitoring of him in the prison was inadequate.
That was, and we don't have a policy and procedure claim on that portion of it. That was an individual officer. Yes.
Okay, thank you.
I believe I'm out of time. Thank you, Your Honors.
Thank you, counsel. If there are no further questions, we'll consider the case submitted. Appreciate your arguments this morning, and counsel are excused.
Thank you.
Thank you. Right, our third and final case to be heard this morning is Miracle v. Hush, number 253032. We'll begin with Mr. Carswell.
Thank you. May it please the court, in 2018, the Kansas Supreme Court held that the Kansas legislature's elimination of tenure for K-12 teachers did not violate due process. In light of that precedent, the Kansas Board of Regents during the COVID pandemic took similar action and temporarily suspended tenure protections for public university professors. Yet the district court here, despite Scribner and the cases on which it relied, held that not only did plaintiffs allege a due process violation, but that somehow that violation was clearly established. That decision was wrong and should be reversed, with qualified immunity being granted to defendants on counts 1 through 3 of plaintiff's complaint, which are all based on the existence of a property interest in continued employment. Furthermore, qualified immunity should be granted to all defendants except Hush on the remaining plaintiff's claims, because plaintiff's complaint fails to allege defendants' personal participation in those asserted violations. On the due process claims, the district court attempted to distinguish Scribner on 2 grounds. First, the district court said, while Scribner involved legislative action by the Kansas legislature, here this was the Kansas Board of Regents, which is sort of an executive branch agency, so maybe it's a little different. But the question under due process is not what branch of government takes the action. As the U.S. Supreme Court recognized in Knight, the executive branch takes action all the time that affects people's property interest rights. The question is whether the action affects just a few individuals on individual grounds, or whether it's a broader application. And here, the Kansas Board of Regents' approval of the workforce management plan affected the property interest of all tenured professors throughout the state university system. Even if you're just looking at the decision-making framework, that was all faculty at Emporia State University. And so the Board of Regents was not required to hold individualized hearings in order to adopt these policies. The policies themselves eliminated whatever property interest plaintiffs might have otherwise had. And therefore, at the time of their terminations, they no longer have those property interests. Second, the district court.
Could I just ask you though, if the policy, the workplace management policy had a broad effect, if it affected a lot of tenured faculty members across the system, then why didn't the Board of Regents need to comply with the Filing Act in taking that action?
Well, I think there are two issues there. First of all, under Kansas state law, the Rules and Regulations Filing Act says it doesn't apply to the internal personnel policies of an agency. And so this involved, just for the same reason that plaintiffs' tenure policies originally were not adopted as regulations. If they weren't adopted as regulations to begin with, it's not clear why the Board of Regents would need to go through the regulatory process to revoke those. Secondly, even if assuming there were some violation of Kansas state law, that itself doesn't violate the federal due process.
Well, let me just back up. When you reference the internal policy of the agency, isn't the agency the Board of Regents?
Well, Kansas law is a little complicated here because the Kansas Constitution creates the Board of Regents as the agency that oversees state universities, and then there are the state universities themselves. But I think, as I would interpret the Rules and Regulations Filing Act, the purpose here is it's basically an internal personnel policies about who cannot be fired, and the universities are state agencies. Those are not subject to the rules and regulations.
Well, so is the Board of Regents. I mean,
Yes.
And they're employees of the Board of Regents. And I just think this seems in tension with what you started out with, which was to say, oh, this was a legislative action. It affected a lot of people. It doesn't sound like a mere internal personnel decision. I mean, how do you square those two positions?
Well, it affected temporarily the tenure rights of all statewide university faculty.
Yeah, that seems like a pretty broad impact.
Precisely, and that's why the individualized hearings were not required, why the policymaking process provided all the process.
I'm not sure I got my question across then. It seems like there's some tension between saying, oh, this is a legislative act that affected a broad category of people on the one hand, and then you also say, oh, but they didn't have to comply with the Filing Act because this just concerned an internal personnel matter. How do you square those two things?
Well, I mean, it's the same as if an agency might have a lot of employees. If a policy applies across the board, if it's their internal personnel policies, the Rules and Regulations Act says doesn't apply to them. So here,
what if it was a policy that applied to everybody in state government? Is that internal?
I mean, if there were some agency that oversaw that, then yes, it could be. I mean, this is an interpretation of Kansas state law. Ultimately, I don't even think you need to go there because assuming even that Kansas state law somehow was violated, that itself is not a federal constitutional violation.
Well, if it was violated, though, let's assume for the sake of discussion it is, and I know you don't think it was, but if it was violated, why wouldn't that invalidate the action?
Well, because that's a state law claim, whereas here they're bringing a federal due process claim. So the question is,
but if the action was invalid, then they'd still have the property interest, the pre-existing property interest.
It's not invalid as a matter of federal law.
I didn't say it was. Is it invalid as a matter of state law?
No, we don't believe it was.
Why not? What authority do you have for that?
Well, just the statutory language.
How about the Taylor case?
The Taylor case, that didn't involve internal policies. That had to do with recipients of government funding, the public, not internal within the agency. That had to do with members of the public.
So we're back to your internal policy argument.
Precisely. These are government employees. If obviously the Board of Regents and the Emporia State University were one combined agency, I don't think there'd be any question. And I mean, the only issue is, well, because the Board of Regents oversees Emporia State University, does that somehow make it different? I don't think it does. I mean, under the Kansas Constitution, the Board of Regents is responsible for overseeing state universities. And so under the Rules and Regulations Filing Act, this is still a regulation that affects personnel policies and not the public. And that addresses the district court's second point, which was the notice. For those two reasons, that there is no basis for distinguishing Scribner in the cases on which it relies. Plaintiffs' property rights were validly extinguished by the adoption of the workforce management plan and the decision-making framework. And so at the time of their terminations, they no longer had those property rights. And so their due process rights were not violated. On the second issue here, on plaintiff's remaining claims, those all relate to.
Let me just, before you go there,
Sure.
I think you started out saying the district court also said something about clearly established law. But did it really address clearly established law?
I mean, the district court said there are precedents for property rights and cited some cases on notice, but no, we don't believe that the district court sufficiently addressed that. We don't think there is clearly established law, and that's why you should reverse, among other reasons.
But was that a basis for the district court's actions?
That was the question under qualified immunity. So yes, that was the district court denied qualified immunity by apparently determining that there was clearly established law. Turning to the second issue, plaintiffs' remaining claims all relate to the issue of which plaintiffs or which professors would be terminated and which wouldn't. Their equal protection claims, or we were terminated, these other people weren't. The freedom of association claims, or we were terminated because of our associations. Then they also have a liberty interest claim, which is about what was said about them in the process of their terminations. And then conspiracy claims piggybacking on all that. The Board of Regents defendants had nothing to do with any of that. They established the policies, but there's no allegation that they were involved in the decision about who to terminate and who not to terminate, or what was said about them in the process. So they should receive qualified immunity on all these remaining claims. Defendant Brent Thomas, who is the dean of the college and the provost, the only allegations against him in the complaint are that he attended a meeting on the workforce management plan and testified in front of the Board of Regents about the workforce management plan. Again, there's no allegation that he was somehow responsible for determining which plaintiffs would be terminated or what was said about them. So the only remaining defendants then are the attorneys, Kevin Johnson and Stephen Levitt, who all they did were, according to the complaint, was serve as legal representatives for Emporia State in this employment dispute. Again, there's no allegation that they had as attorneys responsibility for determining who would be fired. And so they should be entitled to qualified immunity on the equal protection and freedom of association claims. The district court.
Well, counsel, didn't they work with President Hush in coming up with the termination letters? I mean, weren't they actively involved in the steps that led to the terminations?
So 2 points there. First of all, in talking about the equal protection and freedom of association claims, yes, you're right. They were, according to the allegations, involved in writing those letters. But there's no allegation that they made the decision. Rather, they were just basically working for the ESU president who made those determinations. In regard to the,
I was intrigued by your argument. It seemed to me like you're making an argument that because they were functioning as university counsel, that should take them out of the complaint. Is that the point you're making?
Yes, there's certainly no qualified, clearly established law establishing that just merely serving.
Well, no, let's not get to clearly established. Let's get to whether they could be maintained as defendants on, let's say, the first part of qualified immunity. Is there something about the fact that they were functioning as lawyers that they should be dismissed?
Yes, because they were not the ones who actually made the decisions that led to plaintiffs being terminated. They were merely serving as counsel. And
well, I understand the argument. I didn't see you. Was there any authority to back up your argument that they should be dismissed?
We cited some cases. There's not a lot of authority, just because I think people tend not to sue the attorneys over decisions that the employers make. But we cited the Yogers case from the Seventh Circuit and the Void case from the Southern District of New York, where the courts have said just an attorney's legal representation in and of itself does not violate the Constitution. You need to show something more. So here they would need to show, or at least allege at this point, we're at the pleading stage, we need to allege that these attorneys were somehow responsible for the decision for the termination decisions, or played some role into that, affected that, rather than just serving as basically the agents of their employer. You don't hold there's no vicarious liability under 1983, so you don't hold the agents responsible for the actions of their principal. In regard to the liberty interest claim, this court has said that's violated by making a statement, and there's a lot of other prongs to that too. But here, they were not the ones who actually made the statement. It was President Hush. And there we do cite the Supreme Court's case, just as a rough analogy in Janus, where under the securities laws, the US Supreme Court said drafting a statement does not equate to making a statement. So, especially once you get to qualified immunity and at the clearly established prong of that, there's no clearly established law that would have alerted them that just by serving as lawyers, they would be violating the Constitution. So they should be granted qualified immunity.
Just give me the Supreme Court case again you talked about.
That one was Janus. I didn't write the full name, but it's cited in our brief about making a statement.
Okay, thank you.
Sure. I'd like to reserve the remaining time for rebuttal.
Thank you, counsel. Mr. Gregson.
Good morning, Your Honors. J. Philip Gregson, appearing on behalf of Appellees Amanda Miracle et al. Your Honors, counsel, as a result of a concerted effort by members of the Kansas Board of Regents, officials at the University of Emporia State, and other unknown state actors, our clients, the professors in this case, their tenure rights as a property right were discontinued without appropriate due process in violation of the 14th Amendment. The professors in this case had a clearly established property right in tenure and should have been granted a notice sufficient to tell them why they were being terminated and a meaningful opportunity to be heard. In the course of infringing upon our client's property right, the defendants also infringed upon their liberty interest in their good name and ability to earn a living in the manner in which they terminated them. Now, this constitutional violation occurred over 3 steps. And the first step was the adoption of the workforce management policy by KBOR on January 20th, 2021. The second step was the approval of ESU's framework by KBOR in September of 2022. The third and final step in this process was the termination of the professors the very next day that after KBOR had approved ESU's framework. Now, as of January 20, 2021, the day that KBOR passed the WPM, it was clearly established law that our clients had a property right in tenure. The case law is clear. We've cited Tomkovich and several other Supreme Court cases for that proposition. Now, the term of tenure that each of the ESU professors had earned indicated they had an expectation of a continued employment except for just cause or in the case of a bona fide financial exigency. Also, as of January 20th, tenure as a clearly established property right, they were entitled to appropriate substantive and procedural due process. At a minimum, the clearly established law required a pre-termination notice of the reasons for termination and an opportunity to be heard, as well as post-termination due process. Now, on January 20th, when KBOR approved the workforce management policy, it's important to note that they had an agenda. We don't know when they posted it, but if they posted it at all, there is absolutely nothing on that agenda telling anybody that they were even considering suspending tenure. So there was no formal notice or any kind of opportunity to be heard prior to KBOR passing that policy. Now, when they passed that policy, it provided a couple of aids. Number one, it said essentially that tenured faculty members could be suspended, dismissed, or terminated irrespective of any other policy. It also provided a, quote, appeal process to the Kansas Office of Administrative Hearings. However, it established the burden on the employee that, hey, we have the burden of showing why we shouldn't have got fired without any discovery, without the ability to call witnesses or to cross-examine witnesses. But here's a significant point that it provided for. Unlike the legislature and Scribner, what KBOR said was, here's our policy. the state is arguing, therefore, it applied to everybody. Well, actually, they had a proviso that said nobody can take any action under this policy until they come to KBOR, and we give you authority to do that. So it wasn't self-executing. It wasn't like anything having to do with Scribner, where the legislature said, hey, we're doing away with due process hearings if you happen to get fired and you work as a teacher in K through 12. Here, KBOR said, you institutions, if you're going to use this, you have to come back to us and we'll approve it, which ultimately is step 2 in this process. Now, on September 14th, 2022, ESU went to the KBOR meeting through President Hush and Mr. Thomas, and they presented their workforce policy. Now, in substance, that policy was very almost verbatim as to what the KBOR workforce management policy was. Now, it's interesting to hear the arguments of the broad application of this policy, because here's the reality. At that hearing, President Hush said that this policy would only impact about 7% of their employees. He also said, despite the discussion about all the financial issues, he also said, made it clear, it's in the policy, this is no financial exigency. Nevertheless, KBOR approved that policy knowing it applied to a very limited number of people. And what also KBOR did when they approved the framework, if you read the framework, KBOR is authorizing ESU to only be able to fire for the reasons outlined in the framework. The legislature in Scribner, this is way beyond anything the legislature did. This is adjudicative in nature. It says, here's the criteria. If you're going to implement it and go terminate folks, here's how you're going to do it. So to get back to Scribner and further delineations, it's important to note that the, quote, terms of tenure, if you will, in Scribner included, as the court noted, KSA 75-2259, which provided nothing in this act shall be construed to create any right or to authorize the creation of any right which is not subject to amendment or nullification by act of the legislature. I'm calling that a term of tenure under the K through 12 due process scheme. Now, there's nothing similar that the defendants can point to that is in the tenure policy of ESU or KBOR. In other words, we didn't have, our professors didn't have this term that they could take it away willy-nilly whenever they wanted to. That is a significant distinguishing term and makes Scribner have no application whatsoever to this case. Now, again, even if the court were to undertake the Scribner analysis, at the end of the day, this policy only impacted 30 professors, not the 30 some odd thousand that K through 12 teachers that there were in Kansas, 30 professors. Understand that that suspension of tenure policy had a sunset clause. It's gone. And so when they say it applied to everybody, well, everybody but the 30 professors who were fired still have tenure, because that's the policy that's applicable after December of 2022. Unlike, again, what the Kansas legislature did in Scribner. For everybody who was a teacher, if you get fired moving forward, you are not going to have a due process hearing. And the legislature was done. Now, we believe that we've established and alleged clearly established property rights and tenure and liberty interest. We've also established that there was no process prior to the removal of their property right claim and tenure. None. There was none at the stage at which KBOR passed its initial policy. There was no opportunity to be heard when KBOR approved the framework submitted by ESU. And the hearing, well, let me strike that. First of all, they got no pre-termination notice whatsoever.
And I take it their termination did not, there's nothing that accompanied that said, here individually for each of you is the reasons you're being terminated because of inadequate performance or something like that.
Yeah. Good question, Judge. Here's what they did. They had 9 sort of criteria as reasons that anyone, the tenured professor, could be terminated under the policy.
Those covered the waterfront pretty much.
Right. But they were all generic, right? But when it got time to give the letters to the individual professors, it didn't specify, for example, okay, under performance, here's what you did. It just said, hey, it could be one of these 9 things. And let's go to hearing. You don't get to ask us which one it is. You don't get us to ask us documents, whether it supports this notion that this was financially motivated. You don't get to call witnesses. You don't get to cross-examine. I'm sorry.
But you don't get, I mean, I take it the hearing that wouldn't have provided for calling witnesses like that. But you said just now that you wouldn't get to ask which clause and what deficiency is being alleged. You don't, why do you think that would not have been, if they had tried to ask that question, it wouldn't have been accepted and responded to?
There was no mechanism for calling witnesses at the hearing, Your Honor.
No, I'm not talking about calling witnesses. What if they were just asking the question of the board? Tell us of these wide-ranging possibilities, which one we were deficient in and why? Couldn't they have asked that question?
Well, in theory, I suppose, but let's put it in context, Your Honor. If you're talking about the point at which KBOR was approving the framework, that there was no invitation to anybody to come in and.
No, I understand that. The framework was not, there was no process involved there, as I understand it. But the implication when the framework was being implemented against these professors, wasn't there an opportunity for them to say, tell us, I know the notice of termination was very broad. We just want you to be more specific. Couldn't they have, wasn't there a chance in a hearing to ask for clarification of why they were being fired?
No, Your Honor. No. KBOR authorized the framework September 14th. The next day, September 15th, our clients were called to an off-campus location, handed their termination letters and said, this is what the process is you're getting. You have to do this appeal. You responded. When you go to the hearing, all you can do is give oral argument. That's what they were presented with. That's the extent of it.
Well, okay, and you're saying that they could not there. I think it's clear they couldn't have called witnesses or presented evidence, and that may be all the further we need to go. That may be itself enough of a problem, but you're saying that they didn't even have the opportunity to say, clarify and be more specific about why each one of us is individually being fired. That question could not have been asked.
Your Honor, I don't know that it's specifically in the record, but I do know that
I only want to know what's in the record.
Okay, the answer is no, Your Honor. They were not afforded an opportunity to be able to ask those questions.
Well, they weren't afforded, or the record doesn't say whether they could have done it or not.
Well, Your Honor, I understand that at the hearing they tried to ask questions, but that was just to the counsel that was arguing for ESU. There was no sworn witness. It wasn't an evidentiary thing. And at that point, that's a post-termination hearing without any discovery at all. Keep in mind that these professors had tenure rights before all this process happened. And as we sit here today, they still don't know why they were fired. they still don't know why they were fired.
So,
And the
all
response
right,
they're getting.
I think that's as far as it apparently isn't going to be useful to pursue it any further. I'll figure it out in looking further through the record. Thank you.
Okay, thank you, Your
Counsel,
Honor.
can I just ask you if we disagree with you on the Scribner argument and think that this was more legislative than administrative in adopting the workforce management policy, is that where your argument about the Filing Act comes in? That is, I didn't hear you say anything about that this morning, but your brief argues that the KBOR didn't follow the Filing Act, and for that reason, the workforce management policy, even if it were legislative, did not eliminate your client's property interest. Am I understanding your argument correctly, or not?
Yes, Your Honor. And in part, the regulatory part of our argument was in response to the position that KBOR were taking. We don't think it was legislative at all, as I delineated the differences. And to the extent they're claiming, oh, well, it had broad application, and then they turn around and say, well, no, it's really just a personnel. We're saying, well, no, if you're saying it is a broad application, then it did need to be submitted through the Filing Act. So yes, Your Honor, if the court decides we think this is more legislative, then we agree. The court in Scribner walks through the due process that was sort of built into the legislative process. We didn't even get that here. We did not even get that here. State cannot pass laws that violates Constitution. I see my time's out. Absent any other questions, we request that the appeal be denied and the matter remanded for further proceedings. But thank you for your time.
Thank you, counsel. Mr. Carswell, rebuttal.
Just a few quick points. First of all, in terms of the number of people who were affected, I claim that this was limited. Again, the workforce management plan affected every state faculty member with tenure, and the decision-making framework, every ESU professor. The fact that only a certain number were ultimately fired doesn't change that analysis. But even if you're looking at the 30, or I think it was 33 actually, who were professors who were fired, if you look at the Seventh Circuit's decision in the Dibble case that we cite in our brief, that only affected a total of 29. Those were arbiters, and only 9 of those ultimately lost their jobs. And yet the Seventh Circuit said this is still a broad class of people, not a small number who are entitled to individualized hearings. So this is legislative under well-established precedent. Certainly no clearly established law saying the otherwise. In terms of it being temporary, we cited a case from the Fifth Circuit, McMurtry v. Holiday, where that was a temporary suspension of, those were merit service protection type similar issue. And this Fifth Circuit said that that was still valid under due process. And in fact, that case was cited by the Kansas Supreme Court in Scribner. That's part of this well-established precedent that this legislative process that when a number of people are affected like this, that was an entire department of a state government, that the process, the policymaking process provides all the process that's due. In terms of Judge Ebel's question, he was getting quite a bit into the particular procedures for the OAH hearings. So the due process has obviously 2 components. One, do you have a property right? And then 2, what protections or what procedures are required? Here, the argument below is focused exclusively on the first part, that they don't have a property right. The workforce management plan and the decision-making framework eliminated that property right. So there was no briefing on whether the procedures, the OAH hearings were sufficient under due process, because by that time they didn't have a property right by the time of their terminations. And so there was no due process violation. Unless there are any further questions, I would urge you to reverse the district court.
Counsel, what is the status of the plaintiff's challenges in the Kansas state courts? Are there still pending matters?
So ESU, the OAH hearings, that Office of Administrative Hearings, cases that it lost, it appealed those up to the district court, and now they're before the Kansas Court of Appeals. That's been briefed. They've said they're going to have an argument. Argument has not been set yet. Is there any further questions?
You're not arguing that the federal court should hold off in light of the pending state proceedings?
That was an argument made in the district court. We're not arguing that now, in part because those cases are entirely to do with whether ESU complied with the decision-making framework. They don't raise the federal due process claims. So those aren't an issue there.
Could they raise due process claims in that state proceeding?
They could not have before the Office of Administrative Hearings. Once they took it up to state district court, I think they potentially could have.
Thank you.
Sure.
Further
Is there
questions?
anything else? Thank you.
Thank you, counsel. Thanks to both of you for the arguments this morning. And thank you for doing a Zoom argument. I know that wasn't what you were expecting, but neither were we. But we will consider the case submitted and counselor excused. And this court will stand in recess until tomorrow morning, I believe at 9 o'clock. Thank you.
Thank you, Your Honor.